Well, let's go to a kind of a more controversial issue, but along the same lines I've been asking you. I think the case that most people are thinking about right now, and the case that every nominee gets asked about, Roe v. Wade, can you tell me whether Roe was decided correctly?
Senator, again, I would tell you that Roe versus Wade, decided in 1973, is a precedent in the United States Supreme Court. It has been reaffirmed. The reliance interest considerations are important there. And all of the other factors that go into analyzing precedent have to be considered. It is a precedent of the United States Supreme Court. It was reaffirmed in Casey in 1992 and in several other cases. So a good judge will consider it as precedent of the United States Supreme Court, worthy as treatment of precedent like any other.
What about Griswold, which was decided a few years before Roe, the case where the court found constitutional right to privacy? Can you tell me your views on Griswold?
Senator, it's a precedent that's now 50 years old. Griswold involved the right of married couples to use contraceptive devices in the privacy of their own home. It's 50 years old. The reliance interests are obvious. It's been repeatedly reaffirmed. All very important factors, again, in analyzing precedent.
Okay. Well, I think I'm going to stop questioning, but I'd kind of sum up what you and I just talked about in regard to precedent, so everybody understands the principles that are at stake here. There are two reasons why you can't give your opinion on these cases. One, I believe, is independence, and the other one is fairness to future litigants. Is that the way you see it?
It is, Senator. If I were to start telling you which are my favorite precedents or which are my least favorite precedents, or if I viewed precedent in that fashion, I would be tipping my hand and suggesting to litigants that I've already made up my mind about their cases. That's not a fair judge. I didn't want that kind of judge when I was a lawyer, and I don't want to be that kind of judge now. And I made a vow to myself I wouldn't be. That's the fairness problem. And then the independence problem. Looks like I'm giving hints or previews or intimations about how I might rule. I think that's the beginning of the end of the independent judiciary. If judges have to make effectively campaign promises for confirmation. And respectfully, Senator, I haven't done that in this process, and I'm not about to start.
Thank you. I'll yield back 8 seconds. Senator Feinstein.
Thank you very much, Mr. Chair. Welcome, Judge, and good morning.
Good morning, Senator.
See you again. Since we're on Roe, I wasn't going to begin with this, but I well recall the time we spent in my office, and we talked about precedent, and in my opening remarks, I indicated that if anything had super precedent, Roe did in terms of the numbers, and I've put that in the record. Here's why it becomes of concern. The president said that he would appoint someone who would overturn Roe. You pointed out to me that you viewed precedent in a serious way in that it added stability to the law. Could you elaborate on the point that you made in my office on that?
I'd be delighted to, Senator. Part of the value of precedent, it has lots of value. It has value in and of itself because it's our history. And our history has value intrinsically. But it also has an instrumental value in this sense. It adds to the determinacy of law. We have lots of tools that allow us to narrow the realm of admissible dispute between parties so that people can anticipate and organize their affairs. It's part of the reason why the rule of law in this country works so well. We have statutes, we have rules, we have a fact-finding process and a judicial system that's the envy of the world. And precedent is a key part of that because, as the chairman pointed out when he quoted a piece of mine, once a case is settled, that adds to the determinacy of the law. what was once a hotly contested issue is no longer a hotly contested issue. We move forward. And Senator, the value of that is the United States Supreme Court takes something like 70 or 80 cases a year. That is a tiny fraction of all the disputes in our federal legal system, right?
Right.
My law clerks tell me it's something like 0.001%. And they're unanimous in those cases which have divided circuit judges. That's why the Supreme Court largely takes the case, because it's divided us. It's one of the rare cases where we disagree. They're unanimous 40% of the time.
One other question.
Sure.
Do you view Roe as having super precedent?
Well, Senator, a super precedent is
in numbers, 44.
It has been reaffirmed many times. I can